5 seconds to go. Start. Therefore, the sale deed, suffering from misrepresentation by the defendants as also want of consideration, deserves to be set aside. It is also submitted that the alleged agreement for sale dated 23rd November 2005 is also a disputed document and no reliance could be placed on the same. Learned Counsel has referred to and relied upon a decision of this court in the case of Sanjay Kumar Singh versus State of Jharkhand 2022-7 SCC 247. We have given anxious considerations to rival submissions and have examined the record with reference to the law applicable. Though learned counsel for the parties have made a few submissions touching upon the merits of the case, but we would leave those submissions concerning merits of the case at that only, because the real question calling for determination in this appeal is as to whether the High Court has been justified in remanding the matter for trial de novo. As regards the question calling for determination in the present appeal, and with reference to the submissions made, we may in the first place take note of the relevant provisions of law and the expositions of this court in the cited decisions. The provisions contained in Rules 23, 23A, 24, 27 and 33 of Order 41 CPC read as under. Where the court from whose decree an appeal is preferred has disposed of the suit upon a preliminary point and the decree is reversed in appeal, the appellate court may, if it thinks fit, by order remand the case and may further direct what issue or issues shall be tried in the case so remanded and shall send a copy of its judgment and order to the court from whose decree the appeal is preferred, which directions to readmit the suit under its original number in the register of civil suits and proceed to determine the suit and the evidence, if any, recorded during the original trial shall, subject to all just exceptions, be evidence during the trial after remand. Where the court from whose decree an appeal is preferred has disposed of the case otherwise than on a preliminary point and the decree is reversed in appeal and a retrial is considered necessary, the appellate court shall have the same powers as it has under Rule 23. Where the evidence upon the record is sufficient to enable the appellate court to pronounce judgment, the appellate court may, after resettling the issues if necessary, finally determine the suit, notwithstanding that the judgment of the court from whose decree the appeal is preferred has proceeded wholly upon some ground other than that on which the appellate court proceeds. The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court, but if the court from whose decree the appeal is preferred has refused to admit evidence which ought to have been admitted, or the party seeking to produce additional evidence establishes that, notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appealed against was passed, or the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment, or for any other substantial cause, the appellate court may allow such evidence or document to be produced or witness to be examined. Wherever additional evidence is allowed to be produced, by an appellate court, the court shall record the reason for its admission. Stop.